In 2015, a liquid chlorine tank changed hands multiple times and sadly ended a life and caused multiple injuries at the recycling facility. Who is at fault? Today, the court hears argument. Here's the background. In 2015, Tim and Roberta Jackson, owners of Ibex Construction and the landowner where the tank was stored for many years, decided to retire and clean up their land. They hired Tom Reinland, an auctioneer who purchased unmarked property on the land for $32,000. He salvaged what he could and then made a deal with a known recycler, Gordon Beck. They agreed to a 60-40 split. Beck agreed to sell the scrap metal to Pacific Steel and Recycling. He loaded the tank onto a truck owned by Pacific Steel. The tank was brought to the facility, weighed, and placed on the shear, a machine that chops steel. The shear was activated and the tank was ruptured. Fluid burst from the tank and vaporized. This dangerous chemical ended the life of the crane operator and injured over a dozen others. Felix Schuck brought suit against Tom Reinland, asserting negligence claims based on common law and restatement of torts, an absolute liability claim for engaging in abnormally dangerous activity, and a statutory claim under the Hazardous Waste Management Act. Tom Reinland moved for summary judgment on all claims, and the trial court granted partial dismissal of Schuck's negligence claim and absolute liability claim. Tom Reinland is appealing the denial of dismissal of 3 claims, and Felix Schuck is cross-appealing the claims which the trial court rejected.
Felix Schuck versus Gordon Beck et al. Let's see, it's Mr. Swindler representing the appellant. Do you wish to reserve any time, Mr. Swindler?
Yes, Your Honor, 5 minutes, please.
5 minutes, then go ahead and proceed, and will those that are not speaking, please mute your microphones.
Thank you. Good morning, Your Honors, counsel. May it please the court. Accidents are sad and regrettable events and tragedies. We all know that. But not every accident is because someone is at fault. In this case, this accident, this tragedy is not because the Reinland defendants did something wrong or at fault. Therefore, I request that the court affirm the dismissal of the strict liability and 392 claims and reverse the trial court and dismiss the 388 claim, the Hazardous Waste Act claim, and the common law general negligence claim. The facts are really not in dispute. The Jacksons owned a company called Ibex, and it was sort of headquartered north of Spokane. They had about 5 acres. It was basically a junkyard of sorts. And they were retiring and wanted to get rid of their junk. So they contacted Tom Reinland. Mr. Reinland is an auctioneer. Mr. Reinland had an agreement that he would remove the stuff. He bought the stuff and he could remove anything he wanted, and he could also leave anything he wanted. He went to the facility and realized there was a lot of stuff there that he could not auction off. So he looked for a recycler. Enter Mr. Beck. He retained Mr. Beck to serve as the recycler. Mr. Reinland finished his work. He removed all the stuff that he wanted to remove to auction off. Then Mr. Beck went to the premises and he removed what he wanted to recycle. Mr. Beck and Mr. Beck alone opted to take this tank, which we now know has chlorine gas in it. And he took the tank and he loaded up into a Pacific truck. Pacific then drove the tank to its facilities. It went through the facility. Pacific removed it. And then as it began to crush the tank to recycle it, sadly, chlorine gas escaped. And when the chlorine gas escaped, many people were injured, including Mr. Schuck here today, who's a plaintiff. Mr. Schuck sued Ibex Jackson, Beck, and the Reinland defendants in this matter. All the same cause of action. The trial court dismissed Mr. Beck. That has not been appealed. The trial court also dismissed Ibex/Jackson. And of course, the trial court dismissed in part and denied in part our motion to dismiss. And last year, the Court of Appeals affirmed the dismissal of all the claims against Ibex and Jackson. And those are the same claims we're here for today, Your Honors. Let's turn to the first claim, which is strict liability. The trial court properly dismissed.
Mr. Swindler?
Yes.
So Beck has been dismissed, correct? Beck is out?
Yes, Your Honor.
And nobody's appealing that decision?
No one has appealed that, Your Honor.
What is the nature of the business relationship between Beck and Reinland?
They just have this agreement that they would split it 60-40. But with Beck being a dismissed party, it it becomes sort of immaterial what the relationship was, because even assuming that Beck has responsibility as a dismissed part, and this is not part of the briefing, this is briefed down below, Reinland, even if he's somehow a principal, cannot be liable for the actions of a dismissed party.
Okay. Were they partners?
That was never really fleshed out down below, Your Honor, and it's not something that's been brought up here. Again, for whatever reason, they did not appeal the dismissal of Mr. Beck.
Okay, thank you.
But Your Honor, to answer your question, they agreed to split the proceeds 60-40.
As I understand it, your client didn't have a prior relationship with Mr. Beck. Was not knowledgeable about his background.
He knew he was a recycler. I think he dealt with him before, but beyond that, Your Honor, there was no ongoing relationship. So the issue for strict liability is whether the activity in question was abnormally dangerous. And I submit that Mr. Reinland was engaging in two types of activity. Number one, he was working as an auctioneer. And in that regard, his work was done because he removed everything he wanted to auction off and he left other things. And there's no argument.
Did he still have a business interest in this tank since he, up until the time of the explosion, because he would get 40% of the payment for the scrap?
So no, Your Honor, I don't believe he had an ongoing business relationship, because any control he had over it was done. Mr. Beck alone decided to what to recycle, and he brought it to Pacific. So his other than being paid, which we don't know in the court record one way or the other whether he was paid, because that was never argued down below. We don't know whether he was paid or not.
Assuming the explosion did not occur, would he have gotten 40% of the scrap value of the tank?
Assuming that to be the case, he would have received his share of the proceeds, yes, Your Honor.
And what does that have significance with regard to not only strict liability, but restatement sections 388 and 392?
Yeah, Your Honor, I don't think it does for strict liability, because the issue is whether the activity was abnormally dangerous. And recycling scrap, as the Court of Appeals and the IBEX court found, recycling scrap is not abnormally dangerous. We know that because Pacific's policies, had they been followed, easily could have prevented this. So recycling scrap metal could have been done very safely and easily. With regard to 392, I believe 392 is inapplicable for a couple of reasons. Number one, I believe that his business interest had ended, but most importantly, 392 requires that Reinland remain in possession or custody of the chattel here, the tank, at the time of the accident. And there's no evidence that Reinland was ever in possession or custody of the tank at any time, especially not after Pacific had it. Pacific had it, and there's no doubt that Pacific had full control, possession, and custody of the chattel. Therefore, under 392, which requires possession or custody, Reinland did not possess it and did not have custody on it. In fact, the best that can be argued by Schuck is that Reinland does not recall seeing it. I know for summary judgment that may be an issue, but I think it's irrelevant, because not recalling seeing it still doesn't say he possessed it or he ever had custody of it. And most importantly, we also know that he did not select it for purposes of recycling. He left it behind for purposes of auctioning it off and let Mr. Beck decide whether he would accept it for recycling. Because remember, in their deal, Mr. Beck was a recycler and Mr. Reinland was not acting in that capacity.
When analyzing liability against Reinland, you're in part arguing that Reinland could rely on the fact that Pacific had policies, work policies, to prevent this type of accident. Can Reinland rely on that when Reinland had no knowledge that this tank was going to Pacific and that Pacific had these policies?
Well, I think even though Reinland didn't know it was going to Pacific, where in fact the tank was even being recycled, I think the intention of 392 and 388 is fulfilled when there were these policies. In fact, again, the Court of Appeals in the IBEX case said those policies were important in finding that IBEX and Jackson were not liable. In the same way, those policies were actually in place, and had they been followed, this accident never would have happened, quite frankly. Because one of two things, Your Honor: either it would have been rejected, or they would have removed it, and then they could have vented it and then put it back on, so it could have been safely done. So either way, Your Honor, the accident should not have happened. If I can, I have 20 seconds left since I'm reserving 5. I want to turn to 388 real quickly. The Court of Appeals in the IBEX decision held that it did not apply because the tank was not put to the use as IBEX intended. That same argument applies here. There's no evidence that Reinland knew this tank would be recycled. Thank you, Your Honor. Again, I have 4 minutes and 53 seconds.
All right, Mr. Manka, am I saying that correctly? Probably not. All right, please proceed, and you're on mute at this point.
Thank you, Your Honor. It can be Gary Manka or Manka, depending on how much you want to emphasize the Italian. Good morning, Your Honors. May it please the court, counsel. I represent respondent cross-appellant Felix Schuck in this matter. Now, we shouldn't lose sight of really what the overarching question that this court has been asked to decide. And that is, what are the tort law and statutory duties that are best suited to ensure that dangerous waste is disposed of safely? And that question has particular urgency in this case and sets it apart from this court's prior decision in the related IBEX decision, because of 3 admissions that I was reminded of that Reinland made before the Superior Court. And one is that for purposes of summary judgment, there is a genuine issue of material fact whether Reinland should have known that this tank was dangerous. Also, that was at RP 8. He also admitted on RP 10 that casual inspection would have revealed the danger. And then at RP 24 said that the reality is that this was a preventable accident. All that was necessary to be used is reasonable care. And of course, that statement about reasonable care.
Well, if this was a preventable accident, doesn't that thwart your absolute or strict liability claim?
Your Honor, I don't think so, for 2 reasons. One is that the existing test for whether an activity is abnormally dangerous, it's a 6-factor test. It doesn't have to be all 6 that are satisfied in order for an activity to be abnormally dangerous. It just has to be at least 1 in A through B, which has to do with the dangerousness of the activity. And then it just has to be 1 in D through F, which has to do with the utility of the activity. And
was the tank an obvious danger? And if so, does that preclude you from recovering under section 388 and 392?
Your Honor, I don't think it was so obvious that if you just take a quick look at it, that it was a danger. But that it was sufficiently obvious that if you exercise even a little bit of care, you should have realized that it was a danger. And I think that's as Reinland admitted below at RP8. And I don't think it forecloses a claim under 388 because for a couple reasons. One is that we have to look at the class of people who are protected. And so it's not just the truck driver who, a Pacific, who accepts that tank and then drives off to the dumps. It's not just the person at the gatehouse. It's not just crane operator who looked at the tank. A facility like that can have lots of workers on there. It can have members of the public who have driven their materials in there. So there's all sorts of people who can be exposed to a risk. And there are all sorts of potential users there who aren't necessarily inspecting the tank. So, you know, someone who's just operating.
Mr. Manka,
I'm sorry, yes, Judge.
we're not talking about all these other people here. We're talking about a recycler with specialized knowledge of recycling who presumably has just as much or more information about what's safe to recycle as an auctioneer, correct?
I don't think necessarily has more than, but certainly has quite a bit of knowledge about metal scrap, yeah.
So under 388, one of the elements is that the supplier has no reason to believe that those who use the chattel will realize its dangerous condition. In other words, if Pacific were not in the business of recycling and didn't recognize the dangerousness of this tank, then Reinland might have a duty to warn, which is 388. But Pacific's in this business.
Right, true. And I think that one of the things that are 2 points to that, Your Honor. One is that a question of the obviousness of the danger, it's a question of fact. So I certainly think that there is a reasonable argument that Reinland can present to a jury that Reinland had no reason to expect that they wouldn't realize the danger. So that is an available jury argument for sure, but it's a question of fact, and some facts point in the other direction. And I think as comment F, restatement 388 points out, if the circumstances are such that you should know that the inspection wouldn't happen, that the duty to warn still attaches. And so here there was just a significant volume. I'm sorry, Aaron, did you have a follow-up question?
But your expert indicated that the dangerousness of this tank was pretty obvious, correct?
That a casual inspection should have alerted him to the danger. But I think that
in analyzing this case, do we assume that Mr. Reinland did not know to whom the tank might be delivered? Or do we analyze it in terms that Mr. Reinland knew or should have known that it was going to Pacific, a experienced scrap handler?
I think both, Your Honor. I think that there's a lot of doctrinal details that 388 and 392 bring up, but the cleanest and plainest way to look at this case is the general duty of reasonable care, which says, was it reasonable in the first instance, based on what Reinland knew or should have known, to release this tank into the stream of commerce without knowing how it was going to be disposed of, without knowing where it was going? Was it reasonable just to let it go? And as he admitted, he should have known it was dangerous, or at least there was a genuine issue of fact on that question. And the record supports it too. Reinland was on that property for 11 days total, 8 of which were spent sorting through the property to determine what items that he wanted to sell at auction and what other items he wanted to sell for scrap. And then when Beck came, Reinland said, you can take anything that's left except the items marked with an X. And so the question is, an urgent question for this court is, should there be a duty of reasonable care for people in those circumstances to avoid releasing hazardous waste into the stream of commerce? Because the duty of warn ultimately, you know, even if there were proper warnings on that tank, Reinland should have never let that tank go off the property in the first instance, right? Because it was a pressurized, highly dangerous liquid chlorine tank. I mean, a hazmat team from Fairchild Air Force Base had to respond to this incident. It was so dangerous. So,
Mr.
yes, Your
Manka,
Honor.
can I ask you a question? What, Beck has been released, correct?
The trial court dismissed Beck on summary judgment.
Okay. What is the difference between the business liability between Beck and Reinland?
I think the major difference here was that Reinland did this sorting activity. Reinland had walked the site for 11 days and was generally aware that there was lots of industrial waste on there. There was everything from abandoned train cars to other metal tanks that were on the property. And so that he had a much more detailed sense of the category of items that were on this property. And then that he said, you can take whatever you like as long as it's not painted with an X. So
Okay.
given the
But what I'm really getting at is, why is his liability more than Beck? Or responsibility maybe more than Beck?
I think for those factual reasons, Your Honor, and so that he had much greater, Reinland had control over what property, what items he was willing to release or not.
So was
So
Beck,
what-
was Beck on the property with his excavator for just one day?
Exactly.
Did he go on the property on a prior occasion before he brought his excavator to see what he might want to pick up and load onto Pacific's truck?
I don't believe so, Your Honor.
Okay.
I don't believe
For
so.
a defendant to be liable under section 392, does the defendant have to have the chattel in its possession at the time of the accident?
No, Your Honor. I think both 388 and 392 are premised on the idea that someone has transferred the chattel to someone else's control or possession. So, for example, in the Indiana Blomker case that Reinland cited, to be sure the defendant manufacturer wasn't liable there because the defendant didn't have possession or control, but there it was the defendant manufacturer never had possession or control. That this particular item was always in the control or possession of the defendant or the other entity that had this item. But there the problem was there was no transfer. There was no transfer. So it wasn't that there wasn't possession or control at the time of the incident. It's that the defendant manufacturer never had possession or control. But here, Reinland had possession or control for a period of time and then transferred it. And so the duty to warn that's in 388, 392, it really presumes that there will be a transfer. Otherwise, why would you warn anyone downstream? It's designed to protect people downstream. But again, we really think that the cleanest way to look at this is to go all the way upstream to the release of the tank into the stream of commerce. And there, did Reinland have to know there was a dangerous tank on the property? Or was it enough that he should have known? In negligence, should there be a duty of reasonable care to avoid creating risks of harm to others downstream. We believe that general negligence principles suggest that the answer is yes, and it makes very good sense to have two lines of defense, not just Pacific, but two lines of defense, because Reinland was the one who was ultimately best positioned to inspect that and ensure that nothing dangerous was released downstream into the stream of commerce. He had the most time to look at the tank in 11 days, whereas once it gets to the Pacific, it's a chaotic scene with lots of machinery. It's loud. There's a lot of pressure to get things through. So even if Pacific had a duty, Reinland absolutely had a duty way upstream, regardless of what duties to warn he had. Even if he had given warnings, but there was still a duty upstream to take reasonable care in deciding whether to release that into the stream of commerce. And there absolutely can be concurrent. Yes, Your Honor.
Thank you, Mr. Maka. Sorry. I want to touch on your hazardous waste claim under the Hazardous Waste Management Act. In order to be liable under that, the person has to be a generator, correct? Or the business has to be a generator.
Or a transporter or other things, but you're right. Our claim is based on the generator subsection.
And a generator is somebody who creates, first causes a dangerous waste to be subject to regulation. And you're saying that by putting this on the truck, it's causing the dangerous waste to become subject to regulation. Is that your argument?
Exactly, by releasing it into the stream of commerce, where it was just sitting on this private property. It wasn't doing any harm, but it was waste that he generated from his liquidation process, either sending things off to auction or, should I finish my response? I see my time is up.
Here, I've got a question.
Oh, yes, Your Honor.
So would a chlorine tank sitting on a piece of property be subject to regulation?
I don't think so. Just sitting there. No one's using it. No one's touching it. No.
No regulation?
In these
what I needed to know.
In these particular circumstances, no.
All right,
Okay.
thank you very much. Mr. Swindler? Be sure you unmute.
I want to begin with the Hazardous Waste Act. Reinland is not a generator. As the court just mentioned, to be a generator, you have to have caused it to become into being. That's what the Court of Appeals said in the IBEX matter. Here's what we know about this tank. Someone, somewhere, somehow, some 18 years ago, left it at the IBEX property. We don't know who. We think it's 18 years, give or take. But we know one thing. There's no evidence that Reinland did that. There's no evidence that Reinland created the tank, caused the tank to be formed, or installed the chlorine gas in. Reinland did not generate this. Therefore, Reinland cannot be liable under the Act. Also, Mr. Schuck fails to address the issue of when this was first subject to regulation. I point out in my briefing that he at one point said, well, it was when it was there, right? When it was on the facility. Well, then they changed that because now they're saying when we released it. But again, we didn't release it. It was Mr. Beck who loaded it. We had no role in doing that. Here's one of the complexities.
But Mr. Beck wouldn't have had any right to take it, but for the fact that your client had entered into this agreement with the Jacksons and had the authority to allow Mr. Beck to take it.
You're right, Your Honor. He had the right to take it or not take it. Here's one of the issues that has confused me. So IBEX and Jackson had this tank for 18 years. If there's a duty of reasonable care, then they should have been inspecting what's on their property. Yet they were dismissed. Mr. Beck selected this. No one required that he take it or not take it. he himself decided to take it, and he himself loaded it onto the truck. And yet he's dismissed. Yes, Your Honor?
Has the appeal rights for the dismissal of Beck expired?
You know, I've not really thought that one through, Your Honor. I know that was counsel, correct me if I'm wrong, maybe 2 years ago. I think that was done. He was dismissed some 2 years ago.
But the fact that there's still pending claims that have not been resolved in the case suggests that Mr. Schuck can wait until the end of the entire case before appealing the Beck dismissal. Is that correct?
I think you're probably right, Your Honor. But as of now, all I know is he's not done that. But to my point, though, so if the person who selected it isn't responsible, if the person on whose property it was for 18 years isn't responsible, yet somehow magically Reinland is responsible, when again, the best evidence is that he doesn't recall seeing it. So let's say he saw it. So I think, Your Honor, you mentioned what if he had seen it? If he had seen it, it doesn't change the analysis because he has no duty to inspect, nor does he have a duty to warn of obvious defects. And as one of you had asked earlier, Schuck's own expert admitted this was, all you have to do is look at the thing and go, oh my gosh, it says Chemicals Corporation, and it has valves on it. According to Schuck's own expert, that would have given anyone pause to say, oh my gosh, this is hazardous. Yes, Your Honor.
I'm curious as to how there was a photograph of the tank. Did somebody photograph it before it was crunched?
So my understanding, of course I wasn't there, my understanding is when it's crunched, the gas came out pretty quickly, so they stopped it. So it was not fully compacted, Your Honor. The gas came out pretty soon. In fact,
there was an explosion, correct?
Not really an explosion. It was a puff. There was never a fire or something. What happened was it was a plume, and then it sort of inundated that area. But there was not an explosion, thank goodness, and nor was there a fire. And then, to your point, Your Honor, the operator said as soon as he saw that, he immediately stopped it. I think that's why it wasn't crushed, and that's why we have those photographs that are in the record. My time is up.
It is. Thank you very much, gentlemen, for your argument and your briefing. The matter is submitted.
Following these arguments, the court reversed the Superior Court's denial of summary judgment to Tom Reinland on Felix Schuck's claims for common law negligence and for liability under the Hazardous Waste Management Act. They dismissed the two causes of action as a matter of law. They affirmed the Superior Court's denial of Reinland's motion for summary judgment on Schuck's claim for supplier liability under Restatement of Torts 388. They reversed the Superior Court's summary judgment dismissal of Schuck's claim for supplier of a shadow liability under Restatement of Torts 392. Additionally, they reversed the Superior Court's dismissal of the cause of action for absolute liability for an abnormally dangerous activity. They granted Felix Schuck summary judgment on his claim of absolute liability under Restatement of Torts 519 and 520 against Tom Reinland. All in all, it's a lose-lose situation. Please let me know what you think in the comments below.